You step away from your desk for 5 minutes and everybody starts messaging you about non competition agreements. Hello, I'm Matthew Leffler, streaming to you live right now, July 23rd at 5 o'clock, 6 o'clock. I don't know. There's a question people have, and the question is very straightforward, and it's a legal question. So it's always good to get your favorite armchair attorney to swing by and tell you a little bit about it. As always, brought to you by a floating disembodied head. My floating disembodied head. Ask for it by name. And of course, my good dear friends at DAT. Dial a truck. Oh, there's a lot going on in the world of transportation, but for a moment, let's talk about the world of post-employment restrictive covenants. Oh, my favorite windmill to tilt at and your favorite windmill to deal with. 1 in 5 of you have a non-competition agreement. If you're watching this and you're a working person in the United States of America, let me repeat that. If you are a working person in the United States of America, 20% of you will have a contract that prohibits you from doing your job for a period of time in a geographic reason, so long as it serves a legitimate interest of the corporation that was your former employer. Yes, yes, yes. Post employment restrictive covenants. Post employment, after you've left, restricted, you've given up something, some bit of your liberty. Covenant is a contract, it's a deal that you made with your former boss. We call them the hiring entity. And the question before our various courts across the United States is very simple. What level of authority does the FTC have in governing contracts between private working Americans and their hiring entities, their corporations? What's the power? Well, we had this case answered in Texas a couple of weeks ago. The FTC was challenged by the U.S. Chamber of Commerce, among others. Now, there were 2 cases in Texas. They were consolidated because the Ryan case was, I think, the first one filed. So they wrapped that into that case. And in that case, what happened was the U.S. Chamber of Commerce and Ryan won against the FTC. They said, look, Your Honor, the FTC is about fair trade or whatever. They're not about contracts between workers and their hiring entities. And the district court in Texas agreed. They said, you're right. We don't think the FTC has this authority. We are going to stop this ban on non-competes that the FTC has issued. That's what we're going to do. Now, in between this Ryan case was another case, the case of Loper Bright. That's the case that overruled Chevron. Oh, yeah, we're still talking about Chevron. Chevron was the law of the land for 40 years. 40 years. I'm 39. I turned 40 in early January of 2025. That means that Chevron was older than me. And that's the way we interpreted our laws with federal agencies. Matt, are you talking about separation of powers? Of course, I'm talking about separation of powers. The idea that there's a legislative, an executive, and a judiciary. Those 3 things kind of got combined. And that thing that got combined became all these administrative agencies that were created to do a certain thing. What thing were they designed to do, Matt? That's a great question. That answer to that question of what is a federal agency designed to do is part of its enabling legislation or its enabling statute. You see, Congress has to give away its power. That doesn't happen automatically. So Congress passes an enabling statute that creates a federal agency. That federal agency takes a bunch of time and creates rules, and they say to the American public or anybody, here's a rule we're thinking about. Why don't you tell us what you think? And then once you give your feedback, they make a rule. And sometimes people go, I don't like that rule. I think that rule's contrary to your power. And so they would challenge the rule. And when that rule got challenged, it would go to district court. It would go to the federal courts, the lowest court. And the federal court would say, well, what does the statute actually say that gave you power? Let me think about that. Now, before a couple weeks ago, we would have Chevron deference, and Chevron deference went like this. What did you say that you think the federal agency does get to do, Mr. or Mrs. Federal Regulator? Oh, you think it gets to do that? I agree with you. You're right. You're the expert. Now the answer is different. Now the deference that you give the agency when they're looking at their own statute, you say, look, I don't know that it says that you get to do that. I don't know you have the power to do that. Let's go back in time just a couple years ago. OSHA came out and said, we have an idea. Our idea is to mandate vaccinations for every single working American if they work for a company over 100 employees. And if they don't want to mandate vaccinations, they have to create a testing regimen and you have to test people. And some people in this country said, wait, I didn't know OSHA had the ability to enforce people to get vaccinations. And apparently neither did OSHA. They didn't realize they lacked that power until they got to the federal courts and they got to the Supreme Court of the United States. And the Supreme Court of the United States said, hey, that's really interesting that you think you have that power, but we don't think that you do. And if you actually want that power, maybe go back and ask Congress for that power, because the only power you get to have, Mr. or Mrs. Federal Regulator and Administrative Agency, is the power that Congress gives you. Okay. So that's a refresher on Chevron. Now there's a new case. And the new case, what is the new case? People keep asking me about. ATS Tree Services LLC versus the Federal Trade Commission. This is a case in 2024. It's case number 24-CV-01743. Document number 80, if you're curious on Pacer. What does this case talk about? This case is the same case we had in Texas earlier. Does the FTC, the Federal Trade Commission, have the power to come into a private contract between you, a working American, and your hiring entity? Now, again, that's 30 million people, 30 million working Americans. 1 in 5 workers have a non-competition agreement. How long have this been the case, Matt? For basically always. Like, this is how it is in this country. And this is the case, I think, more broadly globally, but I don't know. I'm not an expert on non-competition agreements in the United States, beyond the United States. I know US, I don't know the rest of the world. Anyway, so what is this new case about? What is the outcome? What's everyone saying about unusual wills? I love unusual wills. That is a phenomenal Twitter X handle. You should follow it. But they posted, whoever they are, I'm sure it's some amalgamation of very smart and interesting people. But what it posted was, now the Biden administrator's rule on non-competes has been upheld and they will all be gone away in September. And the answer to that is no, or maybe the answer is actually the legal answer is it depends. It depends. It depends what happens on the next level of appeals. So we're in the very beginning. Federal agency issues a rule. The rule is governed, or at least it's given power to make the rule through the enabling legislation. That then goes to the district court. The district court looks at the case, they look at the law, and they apply the law with the standard, and they come up with an outcome. In the Fifth Circuit's case, the initial case with the U.S. Chamber of Commerce, the district court, not the Fifth Circuit, but the lower court, their bosses are above them. That's the Fifth Circuit. That court said, FTC, you don't have the authority, go pound sand. Well, the new case today, this one I just mentioned, this ATS Tree Services that just came out today, the 23rd of July, they say the FTC has the power. The FTC has the power to issue a rule that would ban non-competition agreements. So that's the question. What happens when federal district courts, the lowest courts in the federal judiciary, make conflicting rules? Well, it only binds their court. They get appealed, right? And so the appeal process is to the appellate court. The appellate court in the Texas case, I believe, is the Fifth Circuit. The one here in Pennsylvania, I believe, is the Third Circuit. They'll weigh in. When they weigh in, they just bind their circuit. They only have the power over the places that they're enumerated to have control over. So if you're in the Seventh Circuit, you can't tell Florida what to do. You are talking about the Seventh Circuit, Illinois, Wisconsin, Indiana. Again, the circuits are defined. You can Google them or Wikipedia them. There's plenty of good information to learn about the circuit courts. So now the question, Are the non-competes gone? Have we finally destroyed that vicious dragon that has locked 30 million people into contracts? No, no, probably not. Probably not. What happens next is these both cases get appealed to their respective circuits. The circuits will weigh in and do whatever those circuits do. It's possible the Fifth Circuit looks at the case with the Chamber of Commerce and says, no, we disagree. We think that the FTC has the authority, and it goes back and we have a ban of non-competes. I don't think that outcome's likely. Now, the Third Circuit, same thing. They'll go to the Third Circuit. They'll weigh in and say, do we think this is the right decision? Understand the deference from Chevron now being gone. I don't know what the Third Circuit does. But if you have a conflict of federal circuits, this is when it gets interesting. This is when you can go to SCOTUS, the Supreme Court of the United States, and say, SCOTUS, we ask that you weigh in for us, please, on this ban on non-competition. Can you tell us if the FTC has the authority to ban these contracts? And SCOTUS may take it. Now, SCOTUS doesn't have to. They are a court that is based on essentially their discretion. You petition them, you beg them, you say, please, please, please hear my case. And then they grant it. They grant the certiorari. Then they say, we'll take a look at this case. So in 11 minutes, we've covered essentially conflict of laws, federal appellate practice, and statutory interpretation. Not nearly as in depth as we would hope. But the point of this video, short and hopefully relatively useful, I hope for everybody, is the question of what happens when federal district courts conflict, when they issue competing orders, one that says no non-competes, one that says yes non-competes. We still have time until September before this rule would ever have gone into effect. But we could live in a world, it's possible, interesting, where certain federal circuits would have no non-competition agreements, and certain federal circuits would have non-competition agreements, and they would both be in alignment with our understanding of our laws that have enabled these statutes to promulgate rules. And that's pretty weird. The warning I would say to any employer or hiring entity is, even if you win, even if the Fifth Circuit keeps that rule banning non-competes and it goes to SCOTUS, whatever, and they don't have the authority, the world is watching. Workers are watching. And just because you won today doesn't mean you're going to win in 2 years or 3 years or 4 years or 5 years. You win when you win, and you lose when you're supposed to lose. And so if you're struggling with whether or not you continue using non-competes, that's a really interesting question you need to take some time and consider, because it will not stop by one act of a federal agency. It may not stop with acts by Congress, or it may not come with acts from your state, but there is a target on hiring entities that want to force workers to sign non-competition agreements as a part of the employment relationship. Look carefully at this new case out of Pennsylvania. Yes, it has to do with non-competes, but it's very interesting. The entity, the company that is suing is a company called ATS Tree Services. ATS is a tree care company with 12 employees, and it requires its employees to sign non-compete agreements prohibiting them from working for direct competitors following separation from ATS. Tree trimming, tree care, that has a non-competition agreement? Of course it does. Everybody has a non-competition agreement. It's 1 in 5 working Americans, 30 million people. So at the end of the day, what do I think about this case? Interesting. I think this is just one more reason that employers should be very wary about non-competition agreements, because you never know which way the political wind is blowing. And this is a reminder that it is most people's choice to sign the non-compete. I get it. You're not a lawyer. I get it. They don't give you much time. I get it that they don't require you to have a lawyer present to review the document. I get all of that. This is not a fair exchange. I get that. But it's your personal responsibility. to look at the contracts that you sign and understand the terms. Non-competes are not the same as like a cell phone data plan or a cell phone usage agreement. This is not a contract of adhesion. You have the power to negotiate. You have the ability to choose the things that you will be bound by. And when you choose to be bound by something, even if you think that thing is unfair, you may yet be bound by that thing. And if you don't want to be bound by the thing, you shouldn't put your faith into government to save you, because that's not exactly what government's here to do. Or put another way, that's not what different political groups want you to do with your government. They prefer you, in some cases, to exercise personal responsibility. So, do I like non-competition agreements? No, I don't. I'm not a fan of non-competes. I think I've made that very, very, very clear. But there's a time and place for them. And as of right now, it is questionable whether these things will be part of the employment landscape over the next 3 to 5 years. But right now, if you go out and tell people you are not going to have a non-compete that impacts you after this date of September 4th, whatever September date it is, that is dangerous. That is not accurate. If you do not know about your non-compete or its enforceability, you should see an attorney, because we're paid to do that thing that you haven't done for yourself, which is to understand what you've signed. So we're at 16 minutes. I love that people think about me when they hear the word non-competition agreement. Oh, I do enjoy non-competes. Post-employment restrictive covenants, PERC, perk. What are the perks of the job? Well, non-competes, non-solicits, non-disclosures, and non-disparagements. I hope this video was helpful and useful for you understanding how the federal landscape is changing as it relates to post-employment restrictive covenants, specifically non-competes. And I appreciate everybody who's tagged me and said, hey, Matt, can you just talk about this briefly? As always, it's a pleasure. If you find this useful, find it helpful, I hope you share it. I hope you talk about it. You and your friends have non-competes, like 1 in 5 of you do. And it is very difficult to navigate. It's important to understand what it is that you're up against. Oh, Thomas Weird. Hello, Thomas. Think freight. You should always think freight, my friends. You should always think freight. Okay, I have to go. It's almost dinner time. Got to do some stuff. But I hope you enjoy the law, and I hope you enjoy the rest of your day. Thanks again for swinging by. Let me hit the buttons, and then it'll all be done. Thanks as always. It covers it. Did that make sense? Like, did you understand, like, the 2 different circuits? Like, there's a 5th and 3rd, and there's district courts. So district courts can't really bind the upper courts, but the bigger courts will step in and say, hey, you're kind of getting that wrong. Let me steer you in the right direction. Judges, they used to think of them as like umpires, calling balls and strikes. So this is a question of law. And when you look at the question of law, what level of respect do you give to the federal agency that tells you they have that power? Well, it ain't Chevron anymore. Something totally different. 40-year-old precedent. That's crazy. It's crazy. But that's what happens. This is the nature of the law. It's changing. It's dynamic. It evolves. And it's important that you understand what this thing all means. I really, my biggest fear, my biggest concern is for people to get cynical or disengaged and be like, it's all unfair, it's all rigged, it can't work for me. Yeah, it's tough. It's really tough. And hiring entities do not make it easy on you. It's important to know what you're getting into. But once you're there, do your job. If you're curious, go find a lawyer, figure out what your options are. Good to have a parachute, good to have a backup plan. Always a pleasure. Have a great day.